Hello and welcome. For this segment, we will be talking about mediation of employment disputes. Now, I realize that we've already touched on this topic earlier. However, in my view, employment mediation is a very important subject and represents a trend that started many years ago that will be around for many years into the future regarding how workplace disputes can be and are often resolved. In this segment, we're not going to be talking about the substantive, common, and statutory laws that comprise employment law, but instead a process by which employment disputes may be resolved. And we're going to dig deeply into that process with various concepts and theories and applications. Now, you may find in your future lives some setting wherein mediation can apply, especially for those of you going into human resources and even regarding just corporate matters generally. The subject of mediation will arise and will have some application for you, I'm convinced, in the future, because it's here to stay. In the UK, for example, mediation of employment disputes takes place at the workplace. Now, let me explain. Often in the United States, mediation of employment disputes occurs after some matter has arisen, that being someone's been fired, some process has started, litigation. But in the UK, the aim of mediation is to address workplace disputes before they get to a point where there is some formal separation or some issue that actually culminates with a legal process. Mediators, for example, will come into a company in the workplace and try to resolve disputes between actively employed individuals, employees and their bosses, or bosses and others within that context in order to try to resolve the dispute early on and prevent it from escalating to a much larger or more complex level. So let's begin our discussion today. It's mediation of employment disputes. And there are many factors to consider in determining whether mediation will be useful and, most importantly, productive. We're going to be discussing each of these factors in this segment. That is the nature of employment disputes, parties involved, risks and benefits that the mediation presents, mediation formats, settlement objectives, and then reasons for the mediator selection. Let's talk about the historical overview of employment mediation. Even though I said it's a more recent trend, it actually originates much earlier in the United States. Actually, back in 1898, there was a law passed called the Erdman Act. Mediation played a role in labor and management disputes. The Labor Board and the U.S. Conciliation Service also used mediation during World War II. So the history of mediation really dates back formally with its application and use clearly back in the 19th century. In 1947, the Taft-Hartley Act formed the Federal Mediation and Conciliation Services, known as FMCS, for labor management dispute resolution. The stated policy of the FMCS was that the safety, welfare, and health of the American worker would be improved through mediation. The policies of the War Labor Board during 1942 to 1945 mandated that collective bargaining agreements provide grievance procedures, including arbitration, in disputes over the meaning and application of the agreement. So in other words, if there was some dispute as to what the agreement meant, arbitration and some form of mediation could be used to explain and negotiate the differences and interpretations. President Truman, in the Labor Management Conference in 1945, advocated the adoption of grievance arbitration in every labor agreement. In the late 1950s, almost all collective bargaining agreements contain grievance and arbitration rights. Now, in our course, we've been discussing non-union settings. In other words, where employment is at will. But when employment is conditioned on an agreement that's been negotiated between labor and management, then there will be a grievance and arbitration application in that CBA, and that's an acronym for a collective bargaining agreement. For decades, mediation of interest disputes covering the content of collective bargaining agreements and arbitration rights and disputes remained clearly within the province of union and management settings. The non-union private employment sector really did not develop alternative dispute resolution methods adopting mediation until much, much later in time. The United States Supreme Court, and this is in your textbook, which we've covered earlier in this course, in the case of Gilmore versus Interstate Johnson Lane Corporation, expanded the applicability of the Federal Arbitration Act to employment contracts. The Gilmore decision and its progeny authorized employers to craft their own mediation and arbitration schemes as a binding alternative to traditional rights of workers to access administrative agencies and the courts that cover statutory rights. The enactment of federal and statutory anti-discrimination laws and their amendments applicable to union and non-union workplaces also led to expanded use of mediation. Today, every federal agency is required to have an alternative dispute resolution system in place to resolve disputes in lieu of litigation or prior to the commencement of any type of claim that results in either mandated arbitration or litigation. The Civil Rights Act of 1991, which we've been studying in detail all these weeks, which amended, of course, the Civil Rights Act of 1964, encouraged the use of mediation to resolve discrimination disputes. I want you to take a look at what I've identified relates specifically to a provision of the Civil Rights Act of 1991. And I'll go ahead and read this. You can read along with me, but I've captured a part of the Civil Rights Act preamble and history, legislative history, to include that where appropriate and to the extent authorized by law, the use of alternative means of dispute resolution, including settlement negotiations, conciliation, facilitation, and I've darkened this word, mediation, fact-finding, mini-trials, and arbitration is encouraged to resolve disputes under the amended act. That's the Civil Rights Act of 1991. So clearly, Congress, when it passed the amendment to the original Civil Rights Act of 1964, which is referred to as Title VII, of course, focused on using mediation as a means to resolve disputes relating to discrimination claims. So let's talk about general nature of employment mediation, aside just from the statutory aspects. Private mediation lends itself to resolving common law disputes as well. Common law disputes, for example, involving retaliatory discharge claims, defamation, invasion of privacy, a breach of employment contract, restrictive covenant violations, intentional infliction of mental distress, and civil torts related to the workplace. Later in our course, we'll be talking about civil torts related to the workplace, including the intentional infliction of mental distress. But all of these types of matters certainly lend themselves to the mediation use. The employment relationship has been found to be an integral part, if not the center, of individuals' daily lives. Here's an interesting fact. An individual spends more time at work than any other single activity. Here's another interesting fact that's been brought out by some psychologist or sociologist. Self-esteem and dignity are byproducts of one's occupation. An individual's occupation presents with it an aura of pride, expectation, and a sense of equity. Employment disputes typically involve one or more statutory or common law claims challenging a workplace practice or a discharge from employment. Many employment disputes do not involve actual or constructive terminations. They may involve other issues, even while the individual is still actively employed, or while the employer has that employee on their payroll. Employment disputes may involve allegations of unfair treatment, for example, discrimination, and retaliation while the employee is currently working for the employer, perhaps on a leave of absence due to the alleged workplace hostilities, illnesses, or related matters. Remedies under Title VII, which we've already talked about and you've studied in this course, and many other employment laws provide for back pay, front pay, instatement, reinstatement, reimbursement of lost benefits, compensatory damages, interest, and the like. The imposition of punitive damages or liquidated damages may also be available. One of the hallmarks of employment litigation is the availability of fee-shifting statutes, which enable the prevailing party plaintiff to recover reasonable attorney's fees and cost from the employer. In other words, they would be assessed or taxed to the employer, and the employer would be responsible for reimbursing the employee and his or her attorney for those types of expenses. Adverse employment actions such as job losses, demotions, suspensions can certainly affect employees economically and even psychologically. Similarly, employer representatives, particularly those involved in the decision-making process, have financial and emotional matters at stake and that may support their actions and belief. So let's always focus on both groups in the employment aspect, the group involving the employer and the group, of course, involving the employee. I want to make sure that this course is fairly balanced between the interest of the employee and the interest of the employer. There's rights and there's obligations, and hopefully we've been presenting these matters in a very balanced and even-handed manner. An employment case generally involves conflicting points of view, perceptions of mistreatment, contentiousness, and hostility between the current or former employee and the employer. Feelings of hurt, regret, anxiety, worry, and concern, along with personality traits and maybe even personal agendas, may manifest themselves in mediation. Let's talk about the decision to mediate. The mediator must understand why parties are mediating the employment dispute. How did they come to the mediation setting? Often cases are mandated by judicial orders and court rules. It's not uncommon today that before many cases can be litigated, once they land in a adjudicative proceeding such as a court, they must go through certain preliminary matters, including mediation, before the so-called discovery process can begin and before certainly trial can even be considered. A mandate to mediate may impact the employment lawyer's objectives in advocating for their clients. Mediation, for example, may not be good for parties seeking to vindicate their rights to the fullest conclusion through the courts. Now let's think about that for a moment. That would include seeking reimbursement of attorney's fees, cost, and setting a precedent or an example for what's occurred. How the mediator manages this interest-based party objective should be thoughtfully considered. So let's also talk about the role of a mediator in the employment dispute. The role the mediator has in an employment dispute will depend upon a lot of factors, many variables, such as the interest and objectives of the parties. Certainly a consideration would be the mediation format that's utilized. And we'll talk about these terms in just a moment, such as conference-style mediation, caucus-style mediation, or both. But examples of other party-based interest that I want to have you think about would be the importance of a party to establish legal precedent. In other words, a party may want to, instead of utilizing mediation as an alternative dispute resolution method, seek to litigate and go to court through trial so as to establish legal precedent. Publicity, for example, may also expose and prove, or by contrast, defend against and disprove claims and contentions. The interest of a party may be to seek a large verdict against the employer, or the interest by contrast would be the employer that wants to make sure that the claim is nullified or that there's been no finding against the employer for the conduct alleged. I've darkened the term good faith at the bottom of this slide. For any type of mediation to occur, the parties must exercise good faith. Now, what does good faith mean? It means a desire, a willingness to consider resolution, not to use the process for their own purposes, although that may be true in some respects, but to seek a resolution in so-called good faith, where the parties set aside for just a period, that being the mediation context, their own interest to try to move toward a resolution that can be achieved by way of some type of compromise. Good faith means honesty, approaching the bargaining table and negotiating truthfully and honestly with the positions in mind to end up with some type of a compromised resolution. Some additional considerations that affect the decision to mediate would be public disclosure. We've talked about that just a moment ago, but also the possibility of using mediation to discourage or perhaps, by contrast, encourage of copycat claims, embarrassment, and that's where focusing on the litigation process and getting to trial may include other factors or motivations. Some other consideration would be the economic viability of the employer, such as collection of judgment issues. Simply because a judgment is rendered by either a judge or jury does not at that moment compel the judgment creditor, the defendant, to write a check. There may be difficulties paying for the judgment. There may be collection matters. There may be post-trial situations such as appeal and continued litigation. Mediation can certainly address those concerns and certainly focus on those types of considerations. All mediation, however, is constructed by contract. There has to be an agreement to mediate. Just like an employment relationship is based on contract, so too is mediation. Lawyers or parties, if they're not represented by counsel, prior to mediation should be encouraged to discuss their expectations with the mediator. In other words, what they hope to achieve, what they are seeking through the mediation process. The mediator may serve the parties by engaging in the following commonly recognized roles. And we're going to talk about these different labels in just a moment. The so-called devil's advocate, the so-called evaluator, or the so-called facilitator. Those are commonly recognized roles that a mediator may employ for a dispute resolution setting for mediation, or the mediator may invoke a combination of all of those styles. The needs of the parties will determine what role the mediator will play at mediation. Discussion with counsel or the parties without counsel prior to the mediation may help identify those needs and related concerns. Let's talk about the term devil's advocate. Many ex-judges approach mediation as a so-called devil's advocate. They point out the strengths and weaknesses of each party's case. This style may lend itself to make predictions for either the success or failure at trial. And often judges may be in an excellent position, having experienced many trials and cases during their tenure as a judge, to be able to predict with some level of certainty how these cases might end up before a jury or perhaps a judge without a jury. The devil's advocate approach may have many advantages. For example, it may provide a so-called reality check for the parties. Having a judge, an ex-judge for instance, or perhaps some other mediator who's not a judge but has a background in a certain area, substantive area such as employment law, may provide a level of understanding and guidance that the parties would otherwise not have, and that they would soon discover at the outcome of the case through trial. So there may be a reality check aspect to the devil's advocate style. The devil's advocate style may promote decisiveness to end the dispute. In other words, it might prompt the parties to recognize their weaknesses or their strengths, or both, and come to a decisive conclusion to end their dispute. And it also may stimulate thoughtful reflection, further analysis, and of course, risk assessment. Cases are expensive. Litigation is hugely expensive, and it's full of uncertainties and twists and turns, so to speak, that you might not be able to anticipate until you get to trial. And even at trial, there can be many variables that are unpredictable, that can result in surprise or uncertainty as it continues. So risk assessment can be certainly an advantage of the devil's advocate style. Now there are disadvantages too, of course. It heightens the adversarial context. Let's think about that, for example. How can the adversarial context be heightened even more so? Well, if you're pitting both parties against each other in a negotiation round where the objective is to resolve, and you're pointing out strengths or weaknesses of each particular case, that certainly belies the adversarial nature of the dispute and where it can go. It also promotes economic resolution as a primary objective. Now, that may not be a bad thing. That can certainly be favorable. But we'll talk about later on in just a few minutes that perhaps the primary objective in disputes involving workplace matters may not necessarily be economic. Now, think about that for a moment. The parties may also feel abused and feel that the mediator has lost impartiality or neutrality, which of course a mediator has to maintain. A mediator is an individual who does not have any stake in the outcome of the dispute. The mediator has been retained by the parties, hired by the parties to assist in their negotiated resolution. The mediator does not decide the case. The mediator does not conclude the issues. The mediator simply tries to resolve through negotiation between the parties the dispute at hand. The devil's advocacy style may present to either party that the mediator perhaps is favoring one side or the other by being extremely harsh or predicting an outcome that may not be as expected for one party or the other. So the sense of a loss of impartiality or neutrality certainly can be understood in that setting. Let's talk about the role of a mediator who acts as a so-called evaluator. Many times mediators are chosen for their expertise. They've got a background. And let me just segue for a moment here. A mediator does not have to be a lawyer. A mediator does not have to be an ex-judge. A mediator, for example, can be anyone that the parties choose to facilitate a resolution and negotiate the end of the dispute between them. Employment attorneys may not promote evaluative styles. Think about that for a moment. They may not want to have their case evaluated by a so-called mediator, although sometimes in some instances that may be helpful. A mediator can be chosen, however, for their expertise in a certain subject matter. For example, a lawyer that concentrates in employment matters may be chosen because they have experience in that subject that could lend an understanding of the law and an application of the facts to the law that can help the parties arrive at a reasonable conclusion. So there's different styles of mediation and different roles that mediators may play. Let's talk about some advantages of the evaluative style. It promotes, again, a reality check. There's thoughtful assessment. There can be the application of law to the facts to produce a resolution. The parties, after all, are free to accept or reject the mediator's evaluation and recommendation, but having gone through the process, they will have gained an understanding or perhaps be more enlightened about their own case. Remember that mediation does not compel the parties to settle. It's only a process by which the parties can negotiate toward a resolution. Disadvantages of the evaluator style. The merits of law and facts may limit considerations, other considerations such as the emotional needs or the psychological issues or the economic concerns of the parties. In other words, where the focus is solely on the law and the facts at issue, other considerations may not be as promoted. The evaluator, like the devil's advocate, is traditionally not concerned with conciliation between the parties. That's a term, conciliation. Conciliation is where the parties try to resolve their dispute and they make concessions. They make compromises. And the mediator's role would be to facilitate those compromises through understanding. The evaluator approach may also produce case settlements, but the parties may not feel closure. For example, they may not have the type of healing or peace achieved that perhaps other mediation styles may allow for or better promote. Let's talk about the mediator that is a facilitator, a facilitative type of approach to mediation. And I know that we're getting rather technical here, but I want you to have a better understanding of not just the mediation process, but the different aspects that can be considered in mediation of employment disputes. The mediator facilitator seeks to focus on the needs and interests of the parties. The facilitator seeks resolution through conciliation and peaceful closure. The facilitator is not evaluative, but prompts the parties to arrive at their own settlement based on factors they deem are important. There are advantages of the facilitative style in mediation. The mediator encourages parties to think creatively, promotes parties to be aware of concerns and needs of the opponents. That's an interesting aspect. Promotes a conciliative approach. In other words, tries to promote a win-win dynamic where both sides walk away with a settlement that they may not entirely be happy with, but they're happy that a resolution has been achieved. An end has been accomplished and trial avoided. So in that sense, there can be a win-win dynamic that's present as opposed to a win-loss dynamic that is always going to be present in the litigation and outcome of trial. There are disadvantages of the facilitative method. For example, mediation may be time-consuming and lengthy. Time often results in an expenditure of cost and more money. It may also promote acrimony between the parties. I think I've misspelled that there. I'll check. Acrimony between the parties certainly can be a byproduct of a situation where the parties are trying to talk back and forth and putting their dispute on the table, so to speak, for a resolution and discussion. There can be a lack of direction, in other words. There can be an expansion of contract of the parties' agendas. By that I mean, with more of a facilitative approach, the parties may go into their own directions and their own agendas may expand. It should be expansion or contraction of party agendas. Let's talk about different styles of mediation. I know we've used different roles for the mediator to play. Now we're going to talk about, at mediation, what are the different styles that are available to choose from or for use. The term conference style mediation is frequently used where the parties, the counsel, and the mediator remain in the same room and they negotiate a settlement directly. In other words, the term conference implies that the parties are together in conference at the same time in a same room with a mediator trying to negotiate the settlement directly. There are trends today where many mediations are conducted online, where the parties don't have the opportunity to meet in one setting with a mediator, but they're conducted online, or they're conducted through means where some individual may be in one part of the country and another person in another part of the country, or even the world. And the mediator may also be in a different place. So mediation with a conference-style setting through technology can still be used. The conference format Let's talk about that for a moment. The mediator encourages discussion and negotiation. A facilitative methodology is usually invoked by the mediator. In other words, the mediator doesn't play the role during the conference format of a so-called evaluator or a devil's advocate style mediator. They try, in other words, to get the parties to speak directly to each other and work out their issues together with the assistance of the mediator. The mediator in an employment case may attempt to direct the mediation flow during the conference format by keeping discussions relevant and low-keyed. Are there advantages? Are there disadvantages of the conference style? Yes, there are. Let's talk about those. Where there is an ongoing employment relationship, open communication between the parties is encouraged. In other words, where the parties are still together. The employee is still working for the employer. There's an ongoing employment relationship. So open communication between them can certainly be encouraged and very productive through the conference style mediation. And as negotiations are face-to-face, the mediator validates and or rephrases the parties' positions, points of view to neutralize any animosity, and the parties' positions may be better understood and their underlying interest exposed and discussed during the conference style approach. Are there disadvantages? Yes, there are. The mediator cannot, for example, ask each party what the weaknesses or the strengths of their case would be. And doing so might embarrass the other party, might make settlement even more difficult, where in private caucuses, which we're going to talk about in just a moment, that aspect can be used and it might help bring about a level of understanding. The mediator cannot discuss likely outcome of a jury verdict and why. Usually that could impose an unfair advantage to one party or the other. And then parties may be inhibited from venting or expressing emotions or expressing candor when they're face-to-face, so to speak, or in person during the conference-style mediation. Let's talk about another method that's a contrast from the conference style, and it's called the caucus method. The caucus-style mediation occurs when the parties are separated, either at the outset of the mediation or following what is referred to as an initial joint session. For the caucus setting, the mediator engages in so-called shuttle diplomacy for the parties. The mediator is the go-between. Are there advantages? Are there disadvantages? Of course. Let's talk about a few. With use of the caucus format, often confrontation is avoided with the opponent, the so-called adversary. They are separated into different locations or rooms during the mediation session. And that separation and less confrontation between the parties can be less stressful. Direct communication to each party is discouraged. In other words, the mediator, as the go-between, will communicate on behalf of either party. Remember, the mediator is completely neutral, should be without any bias and impartial. So the mediator can be used to negotiate the points and interest of the parties, and that way it promotes a sense of bargaining and fairness. After all, mediation is designed to enhance the negotiation process. The disadvantages of the caucus format would be often there's too much focus on the facts or the law. Now that's not necessarily a bad thing. That's just a point of observation that the caucus method often presents. Shuttle mediation may also form a level of coerciveness. And by that I mean sometimes the parties may feel that they have less control of the process. The mediator is more of an influencer. They're going to be subject to the negotiation tactics influenced by the mediator during the caucus format. In part, that can lend itself to a situation where there's a less cathartic outcome. In other words, where the parties, if they're face-to-face, if they're negotiating in the conference-style methodology, have really the opportunity to clear the air. That could be lost using the caucus format. And that could be an advantage or a disadvantage depending upon perspectives and points of view. The caucus method versus the conference method, well, factors that may necessitate a caucus, for example, would be where the parties or the mediator may need to call for a caucus, where the emotions, for example, have been so intense between the parties that they shouldn't be allowed to continue to be vented, so to speak, in person, because there might be differences between the parties that are clouding the issues or making settlement resolution more difficult. A caucus method may be imposed to clarify perceptions or misconceptions between the parties. Rather than to have them speak together, they could be separated and their perceptions or misconceptions, as may be, could be better understood. Also, opportunities in a caucus method where there is a separation between the parties could help explore problems with the substantive issues it might uncover, or better manage confidential information that may not otherwise be revealed in a joint session. In an employment dispute, like in other mediated cases, the attorneys are often asked to discuss in candor the strengths and weaknesses of their case and the possible outcomes. The mediator may want to elicit the parties' understanding of a range of verdicts, in other words, best case or worst case scenarios, and a caucus method where the parties are separated from each other can lend itself to that approach. The format and organization for the mediation should be negotiated and confirmed with the mediator and the parties prior to mediation. This should include a determination whether to engage in a caucus-style or conference-style mediation, or perhaps a combination of both. Doing so avoids confusion, concern, or delay at the time of mediation. I want to touch on for just a moment another term at mediation, and it's called the opening session. Often, the parties, if they either move toward a caucus style or remain in a conference style setting, will be invited to participate in a so-called opening session. The mediator will generally respect the counsel's decision whether to attend or be absent from the opening session, or perhaps even dispense with the opening session altogether. If there is no objection, parties speaking in the opening session can be advantaged. Allowing both parties to confront and speak to each other or through their counsel may promote a facilitative approach. Plaintiff's lawyers may want to have their client make opening remarks, especially when doing so may help the defense evaluate how effective the plaintiff is likely to be at trial. The reverse is the same for defense counsel in an employment dispute. Opening statements. Generally, in a caucus-style mediation, employment attorneys are invited to make opening statements, not arguments, but to alert the parties and the mediator as to what the case is about and what the issues are, and perhaps what the objectives are as well. The issue of having an opening session is one that's under debate to some extent. There are advantages or disadvantages. Again, that's something that ought to be considered before the mediation even occurs. The opening statement provides each attorney the opportunity to present their client's case without interruption and to explain the merits for the claim or the defenses. And it also promotes the parties in better understanding and having an opportunity to explain and establish credibility of their positions or their stated objectives. And it promotes a further open dialogue. Are there disadvantages? Yeah, it can be a waste of time. Probably everyone at the mediation where there's already been extensive discovery and you're just days or weeks away from trial, they're probably already familiar with the case facts and the law. Perhaps going through an opening statement can be antagonistic and combative, and it might further contribute to a polarization of the parties. Let's talk about concluding the mediation. A rights-oriented mediation objective by an employment lawyer will rarely yield the desired results. In other words, mediation of an employment case presupposes conciliation and compromise by each party, where the parties are seeking, as we talked earlier, to vindicate their rights and to obtain a verdict for whatever purpose. Mediation probably is not the best vehicle. Although I would recommend, and most judges in the court process would also recommend, that whether the parties are interested or not, they should at least consider the mediation opportunity. An effective mediator in an employment dispute will encourage the parties to consider the following. And these are factors that may necessitate the parties to want to settle. How about the unpredictability of a judge or a jury? Does everyone, for example, know the outcome before trial occurs of what the jury is going to do? No. There's also a high cost of litigation and the expense of litigation. And as we talked earlier, one of the hallmarks of employment cases is the fee-shifting application for claims. The time to get to trial and thereafter. By the thereafter, I mean just because the trial ends with a verdict doesn't mean that the litigation is over. There can be post-trial motions, there can be arguments over attorney's fees or cost, and there, of course, can be appeals. There's a stress and an anxiety that litigation often causes. Those may be factors that may prompt or necessitate the parties to consider resolution. There's also the disruption factor. That's the lives of the parties, their managers, the employees, perhaps even customer relations. If customers are involved in the dispute or involved in depositions or statements for litigation use. There may be a variety of creative solutions to address monetary issues for settlement as well. For example, a settlement sum might be reached by using annuities, sometimes creative financing, or even long-term installment payments. Such payments may be especially needed when a lump sum payment is either not desired or simply unavailable. So mediation can lend itself to creativity that sometimes cannot be achieved, I should say often will not be achieved at trial. In some employment disputes, the complainant or the employee, and this is what I mentioned earlier, may not be entirely focused on attaining a monetary resolution. Sometimes the objective for the employee is simply seeking recognition that a perceived wrong has occurred. While many settlements may be predicated upon traditional common law and statutory employment remedies, for example, as we've talked and we've studied, compensatory damages, back pay, front pay, wage continuation, instatement, reinstatement, transfers, and the like, non-economic resolutions can also include a variety of creative applications. Mediated employment settlements may include, for example, managers or employees attending diversity or sensitivity training. That could be a sought-after objective that could be of interest to the parties. Perhaps having job references available to a former employee for use in getting that next job could certainly be a welcomed aspect that the litigation process does not provide. Letters of recommendation, the same is true with those. If a case goes to trial and the plaintiff wins, no remedy that we've studied provides for letters of recommendation. No remedy provides for outplacement services. All of those factors, and even more creative ones, could be considered as resolution matters wrapping up a case if it's possible. How about this one? Agreement not to protest unemployment compensation benefit claims. Can that be a negotiated aspect to a case resolution? Perhaps. Lots of considerations, and of course, it's non-binding. Mediation is always non-binding unless the parties have decided on an outcome through the mediation process, and then they reach a contract that can be binding. Additional considerations, sometimes mutual and reciprocal non-disparagement, confidentiality restrictions or mandates. How about this one? Promise of an employee to refrain from contacting customers or vendors or others, or exchanging a value-based level of consideration can sometimes yield immeasurable returns and to close the deal, so to speak. A successful mediator in an employment case will encourage employment lawyers and parties to engage in creative, outside-the-box thinking. So when the parties are close to reaching a settlement, a breakdown should not occur for matters that might otherwise have earlier been addressed, such as confidentiality clauses, tax treatment issues, liens, timing of settlement payments, possibilities for breach once a contract has been agreed upon between the parties, and of course attorney's fees. So there could be a lot of different factors that end up as part of a mediated settlement, and some of these are examples that could certainly be addressed and considered before and during, but probably not after the settlement has been reached through mediation. Better to address points that could be divisive or problematic earlier rather than later. A mediator in an employment dispute may want to encourage the parties and the attorneys to consider a well-prepared, pre-generated settlement agreement. Having a checklist, for example, might be a very useful tool for a mediation. If no well-prepared, pre-generated settlement agreement is available, then often a memorandum of general understanding or commitment should be considered. I've included a number of resources and references that have been drawn upon for this presentation. I hope that it's given you a more detailed insight into a very useful tool for resolving or addressing disputes in the workplace and as an alternative resolution process to litigation. Thank you.